Hello and welcome to Unacademy. Welcome to Polity Project 2.0. This is lecture number 3, and in this lecture, we will discuss the most important doctrines relevant for polity, for prelims, as well as the mains examination. But first up, what is a doctrine? A doctrine in law is a recognized principle or set of rules. These set of rules are often developed by the judiciary. Why? So that when a case appears before the court and the court has to decide this case, the court will use these set of rules or this important principle to decide this particular case. And then again, when a case appears before the court again, a similar case, then the same principle, same set of rules be applied again by the judiciary. Why? So that there is consistency in the way Supreme Court or judiciary handles cases. This is what we call a doctrine.
Sorry to interrupt your learning experience, for I have an important update for you. To celebrate the 10th anniversary of Unacademy, Unacademy has slashed the subscription fee by 50%, plus double validity. If you subscribe to our UPSC courses for 6 months, you get 6 months as an add-on, free. Ditto for 9 months as well as 12 months. Plus, Unacademy assure if somehow you do not manage to crack the civil services examination, then next year is free for you, unlimited access to our courses. To subscribe to Unacademy UPSC courses, use this code IAS English and you will unlock the lowest subscription fee. Let's crack it.
Now, we will understand important doctrines of polity, and then you will have a clear idea what is a doctrine and how is it relevant for your examination. Doctrine number 1, no discussion on Indian polity, no discussion on doctrines would ever be complete if we do not discuss the most important doctrine, the doctrine of basic structure, innovated by the Supreme Court in a landmark Keshavananda Bharti v. State of Kerala, 1973. On 24th April 1973, a 13-judge bench of the Supreme Court had to decide. And the principal question was this: is the power of Parliament supreme that it can amend any provision of the Constitution? Because if you look at the Constitution, there was no explicit limitation on the amending powers of the Parliament. Parliament could invoke Article 368 and amend any provision of the Constitution. There was no restriction. The only restriction that one could think of was under Article 13. Article 13, Clause 2 to be specific, which says the state shall not enact any law to delete or abridge fundamental rights, modify fundamental rights. Here again, listen to me carefully. The state cannot enact any law. Now, what is this law? The explanation was provided by Article 13, Clause 3. Law includes ordinances, rules, regulations, bylaws, customs, usages. And listen to me carefully. There was no mention of a Constitutional Amendment Act. That means, can Parliament enact a law which is rules, regulations, bylaws, customs, usages, ordinances to delete or modify fundamental rights? No. But can Parliament use a Constitutional Amendment Act under Article 368 to delete a fundamental right? Yes. So you can amend fundamental rights only by Constitutional Amendment Act under Article 368, not through ordinary laws, not through ordinances. Long story short, matter went to the court. In Keshavananda Bharti, 13 judges had to decide whether there is a limitation on the amending powers of the Parliament. Nani Palkhiwala was the lawyer in this case. He thundered before the court. And he asked the court, "My lord, don't you think that there is something called implied restriction? Although there is no explicit restriction on the amending powers of the Parliament. Parliament can amend any provision of the Constitution. There is no explicit restriction, but there is an implied restriction. Implied restriction in the sense, can Parliament use Article 368 and convert a sovereign country and give this country back to the British Empire? Can we do that? Can Parliament do this? Can Parliament enact a law and then say from now onwards, election would not be conducted every 5 years, election would be conducted after 50 years? Can Parliament do this? Can Parliament enact a law and delete Article 21 and say there is no right to life and personal liberty? Or for that matter, can Parliament use Article 8, amend any provision of the Constitution, which means one by one delete every provision of the Constitution to reach a point where nothing remains in the Constitution? So, if there is no limitation on the amending powers of the Constitution by the Parliament, then Parliament can use Article 368 to delete Part 1, 2, 3, 4, all the 25 parts, thereby abrogating the entire Constitution. Should something remain, something which cannot be touched, that's what Nani Palkiwala meant by implied restriction. Although, let's not get into this technicality, the courts did not agree with Nani Palkiwala's argument of implied restriction. Instead, the court invoked the doctrine of basic structure. Yes, Parliament has the power to amend any provision of the Constitution using Article 368, but there are some things in the Constitution which Parliament cannot touch, Parliament cannot delete. And those features are what we call basic structure. In simple terms, this is our studio. Can I change this stylus? Yes, I can. Can I change the mic that I'm using? Yes. Can I change this tablet that I'm using for writing? Yes. Can I change the color of the studio? Yes. These are the changes that you can make to the Constitution. But can you change the very foundation on which this building is resting? No. Although technically, yes, you can change that as well, but then it won't remain the same building. Then you have to build a separate building, a new building. That's what basic structure is. There are some changes you can make to the Constitution, but then there are some foundational principles on which this Constitution is built and is resting. Those foundational principles you cannot delete, even by using Article 368. So, long story short, there is a limitation on the amending powers of the Parliament. And that limitation is basic structure. Although Supreme Court did not elaborate what is this basic structure, but over a period of time, various Supreme Court judgments, they have enlarged the list of these basic structures which Parliament cannot delete, Parliament cannot change, even under Article 360. For example, Supreme Court has said supremacy of the Constitution is part of the basic structure. Judicial review is part of the basic structure. Separation of powers is part of the basic structure. Secularism is part of the basic structure. Federalism is part of the basic structure. Independence of judiciary is part of the basic structure. I'll give you one example. Anti-defection law was passed in the year 1985, 52nd Constitutional Amendment Act. This law says a defector can be disqualified by the speaker. Someone who defects to another political party will be disqualified. Who will disqualify? The speaker. And the law says, Constitution says, the decision of the speaker shall be final and binding. Matter went to the court. Kyoto Holohan versus Zachilhu 1993. Supreme Court said anti-defection law is constitutional, but not this provision, which says the decision of the speaker is final or binding. Why? Because then there is no scope of judicial review. Then how can judiciary review whether the action of speaker is justified or unjustified, reasonable or unreasonable, fair or unfair? We will check it. We will review the decision of the speaker. So any law, any constitutional amendment enacted by the Parliament which deletes judicial review, violates judicial review, that constitutional amendment would be struck down by the judiciary on the grounds of violating basic. This is a doctrine, in the sense, a set of rules, a principle. So whenever a constitutional amendment act is passed by the Parliament under Article 368, and somebody challenges this in the court, The court will apply this doctrine, the doctrine of basic structure, to ensure that our verdict is consistent. No amendment of the Constitution can violate basic structure. But listen to me carefully. Only a constitutional amendment act can be challenged before the court on the grounds of violating basic structure. Can an ordinary law be challenged in the Supreme Court on the grounds of violating basic structure? No. Why? Let me know in the comment section what is the reason behind this. That's doctrine number one. Doctrine number two, doctrine of pith and substance. You would know there is something called Schedule 7 of the Constitution. And in Schedule 7, we talk about distribution of powers. Some powers are given to the union list, for example, defense, external affairs, communication, banking, insurance, citizenship, extradition. Some legislative subjects are given to the state list, law and order, police, gambling, health, sanitation, local government. Some legislative subjects are given both to the center as well as states, concurrent list. For example, education, forests, criminal procedure, civil procedure, so on and so forth. Now, what if, for example, the state of Rajasthan v. G. Chawla 1958? Rajasthan Legislative Assembly enacted a law. Why? To promote and protect public health. And public health is in state list, known as list 2. And the law said after 10 p.m. and before 6 a.m., loudspeakers are banned. But when we look at loudspeakers, it comes under communication, and communication is in the list 1, known as union list. If a law has been passed by the legislature of Rajasthan to promote and protect public health, saying after 10 p.m. and before 6 a.m., loudspeakers would be banned. The petitioner argued that Rajasthan legislature cannot enact this law because this law deals with loudspeakers. Loudspeakers are part of communication. Communication is under the union list. So such a law could only have been enacted by the parliament. This is what we call legislative competence. When we discuss the doctrine of basic structure, I told you that an ordinary law cannot be challenged on the grounds of violating basic structure. Then on what grounds can an ordinary law be challenged? On two grounds. Number one, on the grounds of violating fundamental rights. So if an ordinary law is passed, you can challenge it before the court on the grounds of violating fundamental rights, not basic structure. Second, on the grounds of legislative competence. Is Rajasthan legislature competent to enact this law, or should this law have been enacted by the parliament because it's under union list? When similar cases will reach the court will apply these set of principles, these set of rules known as doctrine of pith and substance, to decide who gets to enact this law, who has the legislative competence to enact this law. Supreme Court said, what is the pith of this law? What is the essence of this law? The essence is to promote and protect public health, which is within the domain of the state. So state legislature can enact this law. This law is constitutional. Although when the state will enact this law, there will be incidental encroachments into union list. But we have to look at the essence of this law. The essence is in promoting and protecting public health. The law is constitutional because the Rajasthan legislature has the legislative competence to enact this law. Long story short, whenever a law is passed and it is challenged before the court, whether that body which enacted this law had the legislative competence to enact this law, for that set of principles, rules will be invoked by the courts. And that is doctrine of pith and substance. Doctrine number three, Doctrine of severability. Indian Penal Code, which has now been replaced with the Bharatiya Nyaya Sanhita, BNS. There used to be a section called Section 377 of Indian Penal Code. And Section 377 dealt with unnatural offenses. And these unnatural offenses are against the order of nature. For that, we need to understand Article 13. More importantly, Article 13, Clause 1. Article 13, Clause 1 says this. Today is 26th January 1950, when the Constitution has been enacted, when fundamental rights have come into force. But prior to the commencement of the Constitution, there may have been laws which are already in force. For example, Indian Penal Code. For example, other laws, pre-constitutional laws. Can these pre-constitutional laws continue even after the commencement of the Constitution? Yes, as long as they are in agreement with fundamental. But the moment they violate fundamental rights, these laws shall be declared unconstitutional. But does that mean if there are, for example, 100 provisions in Indian Penal Code, for example, and two provisions are violating fundamental rights, but 98 provisions are in agreement with fundamental rights, does that mean we should only cut, sever two provisions and uphold the remaining 98 provisions? Or should we declare that the entire Indian Penal Code is unconstitutional? In a sense, there is an individual who has had an infection in his left arm. And it reaches a point where we have to now decide whether this infection would spread to other parts of the body, or should we just sever this hand or this arm so as to ensure that the remaining body remains intact, the person stays alive. Obviously, we need to amputate this arm, sever this arm. That's doctrine of severability, which means sever only those provisions which conflict with fundamental rights while upholding the remaining provisions which are in agreement with fundamental. One example is Section 3. Section 377, as I told you, speaks of unnatural offenses. For example, the text says, whosoever indulges in carnal intercourse which is against the order of nature. What is a carnal intercourse which is against the order of nature? Any sexual interaction which is not peno-vaginal in nature. It is against the order of nature, it is an unnatural offense, and as such, a crime. And it was this provision which was used to criminalize homosexuality. Homosexuality was a crime. Matter went to the court, and I don't have to explain the transition. For example, Nas Foundation, then Koshal judgment, so on and so forth. Let's stick to the final verdict. Navte Johar v. Union of India 2018. In this case, a five-judge constitution bench of the Supreme Court said homosexuality is unconstitutional, or criminalizing homosexuality is unconstitutional. Homosexuality is not a crime. But does that mean entire Section 377 goes? No. Section 377 was still retained in Indian Penal Code to cover other unnatural offenses. Which are the other unnatural offenses? For example, the rape of a man by a man. If it is a consensual sexual relationship between a man and a man, it is homosexuality, it is not a crime. But if it is not consensual, a man is forcing himself on another man, it is a crime, it is an unnatural offense. Section 377 could have been invoked to penalize this man. Another offense, bestiality, sex with animals, for example. Animals do not give consent. So if there is a man committing sexual intercourse with an animal, bestiality, you will still be prosecuted under section 377 of Indian Penal Code, doctrine of severability. That means if there are some provisions of this law which are in agreement with fundamental rights, those provisions will continue. But if there are some provisions which are against fundamental rights, those provisions will be severed and cut. That's what we call doctrine of severability. But to tell you, there is no similar provision such as section 377 in the Bharatiya Nyaya Sanhita, which means now sex with animals is not covered under BNS. Rape of a man by a man is not covered under BNS. It used to be covered by Indian Penal Code, but not by the Bharatiya Nyaya. But that's a matter to be dealt separately. This is doctrine number 3, doctrine of severability. You can link it with the doctrine of. Let's look at doctrine number 4, presumption of constitutionality. Whenever a law passed by the parliament or passed by the legislature is challenged before the court, and on what grounds can this law be challenged? As I told you, if this law violates fundamental rights, if this law has not been passed, enacted by a competent body, if it is beyond the legislative competence of that body which has enacted this law, on these two grounds, you can challenge this law before the court. Right or wrong? Right. Can an ordinary law be challenged on the grounds of violating basic structure? No. But be that as it may, but who makes this law? Parliament or a legislature of a state? But legislature of a state consists of elected members who are elected by the people. Parliament consists of elected members. These are the members who are elected by the people. So whenever such a law is challenged before the court will presume that the law is constitutional. It is for the petitioner to prove that the law is unconstitutional. Why? Because the assumption is that this law, since it has been passed by the parliament consists of elected representatives. These representatives are elected by the people. This law will be applicable on the people. Why would these elected representatives make a law which is against the people? No. So we will presume that the law is constitutional. That's what we call presumption of constitution. That's why when this year Waqf law was challenged before the court, and it was argued that this law be stayed. Stay should be imposed on this law. The Supreme Court invoked this doctrine of presumption of constitutionality, saying we will presume that the law is constitutional. It is for the petitioner to prove that the law is unconstitutional. That's presumption of constitution. You can view it in similar case. In a sense, in criminal cases, the burden of proof is on the prosecution. If you're accused of terrorism or you're accused of murder, you don't have to prove that you are innocent. The prosecution has to prove before the court that you are guilty, that too beyond any reasonable doubt. Even if there is a slightest doubt in the mind of the judiciary that you may or may not have committed this crime, you will be acquitted. Because the person who has to prove that you have committed this crime, the higher burden is on that individual. Similarly, when a law is challenged before the courts will assume that since this law is enacted by the legislature consists of elected members of the public, and as such, this law is presumed to be the constitutional. It's for the petitioner to prove that the law is otherwise. But what about rules? Rules are made by executive. For example, last year we saw fact check unit. Rules were made under the IT Act by the executive. These rules were stayed by the Bombay High Court. Why? Because for rules, presumption of constitutionality does not apply. Because executive is not directly elected by the public. Legislators are directly elected by the public. So the courts will assume that if there is a rule made by the executive who are not directly elected by the people, they may They may make rules which are against the public, but legislators, they may not make laws which are against the public because public elects them. Long story short, presumption of constitutionality applies only to laws enacted by the legislature, not the rules made by the executive. Presumption of constitutionality. Fifth one, doctrine of colorable legislation. For that, I'll discuss an important case, KT Mupil Nair v. State of Kerala, 1961. We're talking about 1961. And in 1961, right to property was still a fundamental right, because right to property was deleted as a fundamental right only by the 44th Constitutional Amendment Act 1978. Why was it removed as a fundamental right? You let me know in the comment section. Let me give you an assignment as well. You tell me in the comment section why was right to property deleted as a fundamental right. But be that as it may, in KT Mupil Nair v. State of Kerala, 1961, and remember this period, right to property is still a fundamental. The petitioner had 25,000 acres of land, which was considered to be the farmland, or which was considered to be the forest land, or which was considered to be the government land. And on that, 2 rupees per acre was some sort of a tax imposed on this land, which means this individual had to pay 50,000 as tax. Right or wrong? Right. But this individual, despite the fact that he was in possession of 25,000 acres of land, he could only get the revenue from this land, which was of 3,100 rupees. Why? Because majority of this land was barren. Majority of this land was not productive land. Majority of this land was not put to productive use. This petitioner approached the court and challenged this law on the grounds of violating Article 14. What is Article 14? Right to equality, yes, but right against arbitrariness as well. My lord, can parliament or can state legislature impose a tax uniformly on the entire 25,000 acres of land without assessing what land is productive, what land is barren? The uniform application of tax on all the land, regardless of checking the viability of that land, the suitability of that land, the productivity of that land, this is an arbitrary decision. As such, violates Article. Within that law enacted by the state of Kerala, because previously it was Travancore Kochi, the law said, if you don't pay this tax, we will confiscate your land. Now comes the important thing. Can the state confiscate the land? That means snatch the right to property of an individual? No. For that, you have to pay compensation. So directly, you cannot snatch this land of an individual, but you are doing it now indirectly. You are just imposing tax, and you know the tax liability is so much that this individual would not be in a position to pay. Because when you are earning only 3,100 rupees as revenue from this land, and the tax liability is 50,000, which means necessarily you will have to, you're not able to pay. You will have to default on the payment. And then what will happen? The state will confiscate this land, which means snatch your right to property. What you cannot do directly, you cannot do that indirectly. So whenever a law is passed by the legislature and the courts think that although you have enacted this law, but you are trying to do something indirectly, which directly you cannot do. This is an example of colorable legislation, and as such, this law is the doctrine of colorable legislation restrains a legislature from doing something indirectly what you cannot do directly. That's doctrine of tolerable legislation. Sixth doctrine, doctrine of prospective overruling. The important laws related to land reform, zamindari abolition, they were declared unconstitutional by the courts in 1950. How Parliament responded? By amending the Constitution. Added Article 31 capital A, added Article 31 capital B. Not just that, reasonable restrictions were imposed on fundamental rights as well. For example, public order was mentioned as a reasonable restriction by amending Article 19, Clause 2. Long story short, fundamental rights were abridged. But I told you under Article 13, Clause 2, Constitution says the state shall not enact any law to delete, modify, abridge fundamental rights. Listen to me carefully. What is the language used in the Constitution? Any law. The state cannot enact any law to delete, modify, abridge fundamental. And then examples were given under Article 13, Clause 3, that law means rules, regulations, bylaws, customs, ordinances. Does it include Constitutional Amendment Act? In Shankari Prasad Deo, the State of Union of India 1951, Supreme Court said no. That means, can the Parliament use Article 368 to delete a fundamental right, modify a fundamental right, abridge a fundamental right? Yes. But you can't do that through ordinary laws or ordinances. You have to necessarily enact a Constitutional Amendment Act under Article 360. This situation was completely reversed by the Supreme Court in Golaknath, the state of Punjab, 1960. Supreme Court said no, Parliament does not have the power to amend the Constitution, particularly fundamental. Because when Article 13, Clause 2 says state cannot enact any law means including a Constitutional Amendment Act. You cannot use Article 368 to delete, abridge, modify fundamental rights. No. If you want to make changes to the Constitution, make changes to fundamental rights, set up a Constituent Assembly. Because this Parliament, you only have ordinary lawmaking. You don't have a constituent power to amend fundamental rights are beyond the amendatory powers of the Parliament. Long story short, in Shankari Prasad Deo, Supreme Court said Parliament can modify fundamental rights, but under Article 368 only. In Golaknath case, Supreme Court is reversing its position, saying no, not even through a constitutional amendment can you delete, modify, abridge fundamental. But fundamental rights were abridged before that, modified before that. Will this judgment apply retrospectively? That means all the changes made to the fundamental rights previously, they are also null and void? No. Prospective overruling. We have changed our legal position. We are now saying fundamental rights cannot be amended by the Parliament, not even by invoking Article 360. So we have now created a new rule. New rule will apply to the future only. Only in future, if you try to do that, our judgment will apply. Previous things which you have changed, this law, this judgment will not apply to past action. And old rule will remain undisturbed. That means previous changes which you have made will continue, but from now onwards, doctrine of prospective overruling. Now onwards, if you do any of these things, violating fundamental rights, even using Article 360, you cannot do that. Doctrine of prospective overruling. Doctrine of essentiality. Women in the age group of 10 to 50 were barred entry inside the sacred sanctum sanctorum of the Shabarimala temple in Kerala. Matter went to the court. These religious issues, whenever they are challenged before the court, how will the court deal with these religious issues? I told you, what is a doctrine? A precedent, a principle, a set of rules, often developed through judicial decisions. And these set of rules are then applied on a case when a case is heard by the court. So, any case involving religious matters, this doctrine will be applied so that there is consistency in the way judiciary gives its verdict. Supreme Court said banning the menstruating age women in the age group of 10 to 50 inside the sacred sanctum sanctorum of the Shabarimala temple is unconstitutional. Why? Because banning the entry of the women of menstruating age is not an essential feature of Hinduism. Long story short, can hijab be worn by the Muslim girls in school, violating uniform equality principles? For that, the court will decide on the basis of whether hijab is essential to Islam or not. A Navy officer belonging to the Muslim faith, he was dismissed. Why? Because now you started sporting a beard. His dismissal was upheld by the courts on the grounds that sporting a beard is not an essential religious practice in Islam. Long story short, whenever there is a religion, and in religion there are some practices, there are some rituals, we have to divide these rituals and practices into essential and non essential. If there is a religion where there is a ritual and it is essential to that religion, in the sense, if we remove this feature, if we remove this ritual, the religion will collapse. And courts cannot interfere in these features, in these rituals, in these practices. But if then there are some rituals, practices, which are not essential to a religion, which means even if we reform these practices, triple talaq, for example, instant triple talaq, or banning of the entry of women of menstruating age, even if we remove these provisions, the religion will not collapse. These non essential features, if they violate fundamental rights, the court will declare that these features, non essential features of a religion, set aside. And this doctrine of essentiality was invented by the Supreme Court in Shurur Mutt case of 1950. The last doctrine that we need to discuss, doctrine of overbreadth or overbreadth doctrine. For example, I am a teacher at an academy. Let's assume an academy is parliament and parliament has to enact a law. And why an academy needs to enact a law? To ensure dignity of teachers, dignity of educators. For example, we have our courses where we teach students. And in the live chat section of our classes, there is a student who says, Sarmad sir takes 1000 rupee to evaluate an answer copy, which is not true. But if you're saying this, you are violating my dignity. An academy will cancel your subscription. This is the law. Although you are exercising your freedom of speech and expression, you are saying Sarmad sir takes 1000 rupees to evaluate one answer copy. But since it affects my dignity because you are lying and you are tarnishing my reputation, an academy will preserve my reputation by dismissing you from the classes or imposing penalty on you. So that tomorrow others may not level these false accusations on me. Now, the law is framed in such a manner that an academy law says throughout your actions, If through words, whether spoken or otherwise, you are affecting the dignity of a teacher, you are a criminal. But dignity of teacher, affecting the dignity of the teacher, it's also a vague term. If tomorrow the student says, Sarmad sir had to start a class at 6 o'clock in the morning, but he is always late for the classes. He starts the class at 7 o'clock. He was supposed to end the class at 10:30. He ends the class at 7:30. So he is only taking half an hour class on a daily basis. Should be allowed to say this. But an academy may say, since you are saying this, you are affecting the dignity of the teacher, you are a criminal. Somebody saying Sarmat sir does not teach relevant content. He is not teaching relevant for UPSC. He is teaching for SSC exam. Affects my dignity. You are a criminal. Sarmat sir often gives multiple breaks during the classes. He brainwashes the students. He teaches irrelevant concepts. He drags topics. He skips topics. He does not tell us how to answer a mains question. He is not giving us PYQs as well. You should say this because then you need services from me. But an academy may say, through your speeches, through your words, you're affecting the dignity of the teacher. And as such, all your posts which mention that I'm taking money for evaluation, I don't teach for prelims, I only teach for mains, these posts will be taken down and you are a criminal. Because the wording used is dignity of the teacher. And it is so vague that it can be different. Although these free speeches where you are questioning my ability to teach you have been allowed. This should not have been allowed that Sarmat sir takes 1000 rupee to evaluate answer. If it is true, it should have been allowed. But if it is not true, 100% it should not be allowed. But other genuine criticism should be allowed. But when the law says don't do anything which affects the dignity of the teacher, that means you're criminalizing content which should be allowed, content which should not be allowed as well. That means this overbreadth doctrine is a principle that allows a law to be struck down as unconstitutional if it prohibits more constitutionally protected activity than necessary to achieve a legitimate government interest. There's a legitimate interest on part of an academy to prevent and protect the dignity of the teacher. But constitutionally protected activity where you are questioning my skills as a teacher, where you are questioning whether I'm teaching only for prelims and not for mains or vice versa, whether I'm not discussing PYQs, this should be constitutionally protected. But the word is so vague. The language in the law is so vague, protecting the dignity of the teacher, that it criminalizes allowed activity as well as not allowed activity. That is what we call overbreadth. This is how Supreme Court struck down Section 66 capital A of Information Technology Act 2000. Because under Section 66 capital A, the law said whoever is using a computer device, an electronic device to transmit messages which causes annoyance to public, it is a crime. But truth is always causing annoyance. What if I say the truth? That will cause you annoyance. Because the language is so vague, it is liable to be. Although you cannot challenge a law on the grounds that it may be misused. You can challenge the law on the grounds of violating fundamental rights. And if the body which has enacted that law is not competent to enact this law, is beyond the legislative competence of that body to enact that law, you cannot challenge the law on the grounds that it may be misused. But if the language of this law is vague, it leads to chilling effect. Because then other students, they will never question me because they know the moment they question me, sir, why are you not giving current affairs example? They say that their subscription will be cancelled. Sir, why are you late for the classes? Their subscription is cancelled. Sir, why are you not teaching the mains answer writing? Your subscription will be cancelled. Because the vagueness of this law makes it and gives it a chilling effect, which means others will stop asking genuine questions. That is overbreadth doctrine. These were the 8 important doctrines that I needed to discuss with you, important for your examination. And if you have learned from this lecture, do let me know in the comment section. And do not forget to press the like button, subscribe to our channel if you. I'll see you again. Till then, have a great time. All the best.